Welcome to our session on the Roberts Court and the future of America. I am Jeffrey Rosen, and I bring you greetings from the National Constitution Center in Philadelphia. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And it is impossible, ladies and I heard that laugh. But in fact, you will see in our discussion today, because you have the dream team of American Supreme Court constitutional lawyers, we are going to have a genuinely bipartisan discussion.
Are you selling cars? It sounds like.
Well, let me introduce you first, and then you can make up your own mind about what the discussion is going to be. But it's impossible to imagine three better people to help understand the momentous Supreme Court term that just ended on Monday, and impossible to imagine a better date on which to doing it. This is July 2nd. It is the 60th anniversary of the Civil Rights Act of 1964. It is also the day on which the Declaration of Independence was signed and which John Adams expected would be the day of national celebration in America. So we meet at an auspicious time. Let me briefly introduce my friends and co-panelists. I'm going to set the stage, and we are going to have a freewheeling discussion about the Supreme Court. To my right is my dear former acting Solicitor General of the United States, who's also my dear brother-in-law, Neal Katyal. Sherrilyn Ifill is the president of the NAACP Legal Defense and Education Fund. And Ted Olson is the former Solicitor General of the United States. And I have to put in a plug for his astonishing new book about marriage equality, written with David Boies and Ted Olson. They came to the Constitution Center last week, and it was the most moving discussion I've experienced there all year. There was not a dry eye in the house. You must read this incredible book about Ted and David's heroic crusade on behalf of marriage equality. So I'm really excited about this discussion because it comes at a time when many people are saying there are two visions of the Roberts Court. On the one hand, there is the Roberts Court that's able to achieve bipartisan unanimity and to converge around decisions that unite liberal and conservative justices on momentous questions. And on the other, there's the familiar Roberts Court in the news, the 5 conservatives against 4 liberals, 5 appointed by Republicans, 4 appointed by Democrats, which seems to divide along ideological lines. And what's so exciting about this term is that it seemed to be the term that John Roberts actually achieved his pledge to foment a kind of bipartisan unanimity. This is a pledge I'm especially interested in because at the end of his first term as Chief Justice, I had the privilege of an interview with John Roberts. He set out in this interview his hope that he could persuade his colleagues to converge around narrow, unanimous opinions that avoided constitutional divisions and would be an inspiration to the country in a polarized time. Obviously, he had mixed success in achieving that goal in the terms after we spoke. In the 2007 term, 33% of the decisions were 5-4. But this term, as Neal notes in a brilliant op-ed in the New York Times last week, 66% of the decisions of the Roberts Court were unanimous. This was, as Neal notes, the lowest rate of division and the highest rate of unanimity since the 1940s. At the same time, we saw the familiar ideological divisions in 14% of the cases. That's the lowest 5-4 rate since Roberts' first term in 2005, but those involved cases like the Hobby Lobby contraceptives case and in the McCutcheon campaign finance case. So the reason that this discussion is going to be so great is I want to figure out who is John Roberts, what is the Roberts Court, and how do we reconcile these two competing visions, one which achieves unanimity and the other division? I'm going to begin with Neal because that was just a phenomenal op-ed that you wrote. It was the definitive statement on the subject. Why do you think that the Chief Justice was able to achieve a measure of unanimity this term that eluded him in past terms?
Well, thank you. I do think that the conventional story of the court for many years has been, particularly since Bush versus Gore, which Ted brilliantly argued, has been this is a divided court, hostile to one another. They can't find ways to agree. And yet, when you look at the numbers of this term, they did something they haven't done since the year 1940, which is agree on the bottom line in roughly 2/3 of the cases. That is a remarkable achievement. And sure, there's any amount of disagreement on the reasoning of how they got there. And sure, that last third of the cases are significant. I mean, and elections have consequences, and of course the justices are going to think differently from one another. But I think this term, led by the Chief Justice, the court did, I think, make a concerted effort to say, let's try and find an agreement. We're all just reading the tea leaves here, but I do suspect that one thing going on among those 9 members of the court is a deep belief, hey, our institution of government works pretty well, and they're looking across the street at Congress and the rapidly divisive nature in which they can't even be in the same room with one another. And I think the court is saying, look, we can actually show Americans a better way. Sure, we all got here through different means, 5 appointed by Republicans, 4 by Democrats, and the confirmation hearings undoubtedly were controversial. But they sat there and said, we can agree on the bottom line in 2/3 of the cases. They only divided 5 to 4 in 10 cases this year out of the roughly 70 they heard. That's a really low number compared to, if you go back over time.
So Sherrilyn, do you agree with Neal's optimistic analysis? You've been highly critical of some of the 5 to 4 decisions in cases involving voting rights and affirmative action. Who is the real John Roberts to you?
Well, first of all, thank you. Second of all, it's also Thurgood Marshall's birthday.
Oh, wonderful.
And
That's a great first
thirdly, I love Neal, but I can't really agree, and for these reasons. I think it's important to look at, what are the 14 cases in which the split happens, in which the 5 to 4 happens. And I think you have to kind of go beneath the hood a little bit on this, that if we just look at the judgments, I think it's true that, and I also think it's true, by the way, that Roberts has been making an effort to make this happen. But we shouldn't dismiss the fact that even within these unanimous judgments, there are these very powerful and strong differences in the reasoning that supports these opinions, that suggests that another case coming through the pike that even marginally, twinges the facts would produce the kind of schisms that we're used to seeing. We shouldn't also forget that there are some cases that the court took that the court was not able to hear. One of them is the Mount Holly case, which is a civil rights case, a case under the Fair Housing Act from New Jersey. This court, the conservatives on this court, have been trying to get at this issue of disparate impact, which they don't believe in. And they took this case, even though there was no split in the circuits. The case was settled, and so they didn't hear it. And so, if that had been up for the court to decide, I have no doubt that that would have been a 5-4 decision. And so while I think it's true that there has been some greater unanimity in the judgment, I think that the fundamental tensions that have to do with the kinds of issues that probably most people in this room care about remain. And I think when you see the split, the 5-4 split, the nature of the split is so powerful, so visceral. If you look at Justice Sotomayor's dissent in the Schuette case and compared to the majority opinion, it's like 2 different worlds that justices are living in. That I think, I'm not ready yet to be optimistic about the fact that this is a court that's coming together around a united vision about power in this country.
Okay, Ted, you can now adjudicate between these 2 positions. Sherrilyn has noted cases like the Schuette affirmative action case where the court is deeply divided. Neal has pointed to the points of unanimity. Which is the true Roberts court, and why is Roberts able to achieve unanimity in some of these cases and not others?
Well, I think, first of all, it's risky taking a snapshot of one term. This is 70 decisions, approximately, and you have to look at the cases. The court usually is unanimous in 1/3 to 40%, and this is a bit higher this time. As Neal pointed out, there were 10 5-4 cases, but there were another 10 approximately 6-3 cases, which are so there's 2/3 of the cases were relatively unanimous. Some of those cases had very, very sharp concurring opinions. That's what we were just talking about. The justice, in several of the cases, Justice Scalia read aloud concurring opinions, which you don't do in the Supreme Court. I think most of you know when the Supreme Court decides a case, there's a decision day, and the justice who wrote the opinion for the court will give a summary of the decision, and then occasionally, a few times a year, someone who feels very strongly in dissent will give a summary of a dissent. In the years that I've been watching the court, I've never seen anybody read or summarize aloud a concurring opinion. So in a couple of these cases where the court was unanimous on the judgment, for example, with respect to, a couple of the cases. Justice Scalia, the recess appointment case, which was the one big separation of powers case where the administration lost that case the Supreme Court said the president had not properly exercised his right under the recess appointment clause of the Constitution to appoint members during a so-called recess of the Senate. The court decided that relatively narrowly in an opinion by Justice Breyer. Justice Scalia said, "Well, listen, we blew it. We had a chance here to render a resounding decision, and you've now given the executive branch, even though the president lost, you've given the president opportunity to do things in the future which dislocate power in favor of the executive." Now, that's Justice Scalia speaking, who used to be the Assistant Attorney General for the Office of Legal Counsel, who writes opinions usually from the standpoint of the executive branch when there are disputes between Congress and the executive branch. And there were a couple of other cases like that, and interesting language that he used in those cases. And if you look over a period of time, the court does come together in a lot of cases. You don't read about those in the New York Times. They're not front page stories. But so I don't know that what's happening this term, statistically, yes, but what's happening this term is necessarily typical. I think another interesting statistic is the record of the administration. Neal and I have both been in the office of the Solicitor General, and the Solicitor General usually has a very, very compelling win-loss record in the United States Supreme Court, either in cases in which the United States is a party or in cases in which the United States comes in as a friend of the court and offers an opinion to the court as to the way the court should come out. This year, where the United States was a party, the United States won 12, but lost 10. So that's just slightly above 50%. Usually it's closer to 70, 75%. And they did better this year than last year when it was closer to 40% instead of 55%. So that's an interesting statistic. What's going on there? Is the court siding against the executive, or is the Solicitor General deciding to get involved in the wrong cases and wind up losing them? With respect to the recess appointment case, it's an interesting case that the president obviously had advice from the Office of Legal Counsel, maybe from the White House counsel's office, to make those recess appointments. I was in the Office of Legal Counsel. I would have said, don't take a chance on that kind of a recess. It was a very short recess. The Senate was claiming that it was still in business. Don't take a chance on that, because when you take chances with that sort of thing, you run the risk that there will be a court decision that erodes executive power. So I don't know what's going on there, but it's an interesting little data point.
Fascinating observation. You've heard, ladies and gentlemen, that reasons matter a lot at the Supreme Court. And as Ted was just saying, the Obama administration lost the narrow question of whether the president can make a recess appointment when the Senate is out of session for less than 3 days. But he won the broader ability to make recess appointment when it's out for more than 10 days. And Justice Scalia was not able to persuade 5 justices that recess appointments in general are not permissible. Okay, Neal, you've had some strong challenges to your vision that Roberts really made the court his own in making it unanimous. Defend it, and then let's get into the particular cases. I heard a cell phone going off a moment ago. First of all, everyone turn off your cell phones, and then Neal, tell us what you think about the incredible case about cell phone privacy, where the court held 9-0 that the police may not, when they arrest us, or when they arrest you, they may not search your cell phone without a warrant. An incredible victory for privacy in a digital age. How did that happen?
Yeah, so I don't mean to disagree actually with anything that's been said. That is, I think Ted's absolutely right. The reasoning matters, and sometimes they sharply divide on the reasoning, like recess appointments, and sometimes they don't. And Sherrilyn's absolutely right that in the remaining third of the cases, there are some really hot feelings on the subject, and we're going to see 5 to 4 decisions for years to come unless there's a change in the composition of the court. That said, I do think there's remarkable unanimity in really important cases. And Jeff, you asked about the cell phone case. That's a perfect example. And this is one where I think Ted's statistic about the Solicitor General is a little misleading, not intentionally, but you know, this was the cell phone position of the government has been the same for several administrations, which is if you're searching someone's subject to incident to arrest, you can search, you can grab whatever's on their cell phone. This Justice Department defended it as prior Justice Departments in the Bush administration had. So yes, they racked up a 9-0 loss, and it is a pretty interesting loss. I don't think if we sat and thought through the confirmation, watched the confirmation hearings of the last 4 justices, we would have predicted that all of them would have voted to say, your cell phone is your domain, and it's so special and different and unlike just a piece of paper or a diary or something like that. It contains a snapshot of your whole life. Therefore, special privacy protections adhere to it. And indeed, they went so far as to say that the police rummaging around on your cell phone is kind of like the founders' general warrants that they were so aghast about. The idea that the government could just come in and read anything of yours. This was a really powerful pro-liberty opinion signed by every justice on the Supreme Court. And so when we talk about, do these unanimous decisions matter to you in your daily lives? The answer is yes. Even the unanimous ones sometimes were broad, resounding victories for freedom.
Well,
Sure,
can
sure.
I say something about that?
Go ahead.
If you'd watched the court's recent, as you have, we all have, recent Fourth Amendment cases, you'll see how strongly Justice Scalia, for example, the conservative, or one of the leading conservatives on the court, has been in support of individual rights in the Fourth Amendment and a couple of other areas. And the administration could have seen this coming, I think. They lost a case 9-0 2 terms ago with respect to whether they could put a GPS device on a suspected drug dealer's car and track him from Washington, D.C. into Baltimore and a few other places. The administration took that to the Supreme Court and lost 9-0. So there are some things that go into this deciding which case to take and which case not to take, but I do agree the fact that the court is deciding some of these Fourth Amendment cases on a pretty sustained across-the-board basis does mean a lot for everyone's individual liberty.
And Ted, that's exactly right. And the tragedy about the administration in these Fourth Amendment cases is that they haven't set out rules on GPS surveillance or on cell phone surveillance or anything like that to give the court comfort. And you saw Justice Alito in the cell phone case saying, look, if the government had rules on when they would be used and how they'd be used, maybe it's a different matter. But to just simply assert anytime, any place, we can go do this, either GPS or cell phone search, that goes too far.
Sherrilyn, does the court get credit for the 9-0 decision? And why would the conservative justices rule this way? Is it because they can imagine their own cell phones being searched?
I think so. I want to make sure we don't see this solely as a contest between the Supreme Court and the Obama administration. I'm frankly concerned about the Fourth Amendment from the perspective of the clients that we represent. And I think that the court is able to understand and feel discomfort about things like GPS tracking devices, about things like the cell phone, where they can imagine the kind of information that might be included on it. And they imagine being, maybe someone they know who could be pulled over and have that searched and how intrusive that would be. But frankly, well, 2 things. One is, I would have to say, in a place like Baltimore, where I've lived for the last 20 years, I don't think that this is going to particularly stop the police. They're quite able to get warrants fairly easily. They enjoy a tremendous amount of deference from judges. And so I don't think this is going to change law enforcement in a demonstrable way. But obviously, if you're in a position to know your rights and to have counsel, the ability to suppress evidence that comes through a cell phone, obviously pretty important. But if you look at some of the other cases that the court has decided in the Fourth Amendment realm, I'm not sure how excited I should be. I'm happy for this case, but take, for example, the court's decision, I guess it was last term or term before last, Maryland versus King, in which the court said that if you are arrested, the arresting authorities can swab your cheek and get your DNA, which seems to me, if your cell phone's got information in it, your DNA's got serious information in it, right? That you wouldn't want to share, that people would not find even if they searched your home. And yet, post-arrest, I think about the Florence versus Freeholders case, in which the court said that if you're arrested, local authorities can strip search you, even if there's no evidence that you are a threat, that you are in a gang. And in that particular case, it happened to an African-American man, fairly well-off business owner, who was arrested and who was strip searched twice in New Jersey, and then later all charges against him were dropped. So post-arrest, the court kind of is willing to now give law enforcement the benefit of the doubt, even notwithstanding the intrusiveness of DNA evidence. Pre-arrest, the court is concerned about this technology. And so I think this is a reason to celebrate, but I have a tremendous still amount of caution about how the court is approaching privacy issues as it relates to individuals who've been arrested by the authorities. And the recognition, of course, that many false arrests happen. People are arrested all the time, and no charges ever attached to those arrests. And to imagine that individuals like that can have their DNA placed in a database and also can be strip searched seems to me kind of has to be balanced against the court's decision around GPS and cell phone searches.
That's a very powerful point. It is true that the GPS case, many people think, was lost when the government lawyer was asked by Chief Justice Roberts, is it your position that the government could put GPS devices on the bottom of my car? And the lawyer said yes, and at that moment, he lost the case. Ted, Justice Breyer is important here. Sherrilyn noted the DNA case last term, and that was one where he joined the conservative justices, as he often does in criminal procedure cases. On the other hand, this term, Justice Breyer joined the conservatives in upholding a Michigan initiative banning affirmative action. It was an extremely interesting concurrence where Justice Breyer said, here, when the voters of Michigan tried to overturn a US Supreme Court decision allowing affirmative action, they were allowed to do that because the affirmative action plan had been adopted by bureaucrats at the University of Michigan, and here it was a democratic decision-making body that was overturning that. What is your take on Justice Breyer in that shooty affirmative action case and his role more broadly?
Well, you have to look at Justice Breyer's jurisprudence and the jurisprudence of all of the justices on affirmative action. They have been everywhere. This goes back to the Bakke case, was that 76?
78.
78. And then subsequent cases since then, the Michigan cases that preceded this change in Michigan law, and the Kentucky and Seattle cases a couple of years after that. I once counted out the number of opinions in those cases from 5-4 decisions, and in the Michigan case, the Supreme Court upheld the affirmative action program and the law school, but struck down the one in the undergraduate program, the same Board of Regents adopting programs to achieve supposedly the same purposes. One was upheld, one was struck down. In those two cases, there was something like 10 or 11 opinions, 200 or 300 pages. Then the Kentucky and the Seattle cases come along, and then this case comes along, and there's decision after opinion after opinion after opinion. Someone points out that if the court can't make up its mind with respect to limits or the permissible scope of affirmative action programs to achieve diversity in public education systems, how are school boards supposed to figure anything out? Now, Justice Breyer, in the Kentucky cases, as I recall, wrote a very, very strong dissenting opinion. I think he said that was maybe at that point the longest opinion that he had written. And so, the court is in the middle on this, and Justice Kennedy, in almost all of these cases, is a pivotal point. He's against racial preferences, but he doesn't want to go all the way that the more conservative member of the courts do and say you can't make these decisions on the basis of racial grounds unless you're attempting to provide a remedy for past discrimination. And in the Michigan case, what the Michigan voters did and the Michigan Constitution did was say, we won't have those kind of programs. And the defense of it was, whether you agree with it or not, the defense of it was if it's not required by the Constitution in a particular case, we can say, let's not have to have it. So that was kind of a different context in which this comes up, but you really have to read all those opinions, and where you come out on these things really is a Rorschach test.
Sherrilyn, I'm sure the audience just wants to know the bottom line about, is there a constitutional future for affirmative action? Is there?
Yes, and some of the difficulty is we tend to talk about all these cases as affirmative action cases, so any case that raises the issue of integration in the schools or actually affirmative action, even as an underlying matter, is perceived as an affirmative action case. And in fact, the Schuette case actually wasn't an affirmative action case. It was a case about political restructuring. It was a case about whether or not a state, in this case Michigan, could use a ballot-wide referendum to basically undo the Supreme Court's decision in the Grutter and Gratz case, which were affirmative action cases. And what the ballot initiative, Proposition 2, said in Michigan was, if you want to use race in admissions in Michigan, you have to essentially amend the Constitution to do so, right? That you no longer can use race. And the issue was, can they do that? Can they create this barrier to those who are advocates of the use of race in admissions, when those who are advocates of the use of athletic prowess or musical prowess or those who think that people from the upper Michigan Peninsula deserve special treatment and admissions, they can simply lobby these bureaucrats that you referred to on the Board of Regents and have that considered. But those who wish to have the board consider race, which is after all constitutional following the Grutter case, they have to amend the state constitution. And that was really the question, can you set that barrier up? And it's an important one. I mean, we talked about Breyer's opinion. This is a circumstance in which you really have to look to what is the relationship between the political process and the issue of racial minorities in this country. And you know, it was many, many decades ago that the Supreme Court in the famous footnote 4 in Caroline Products talked about the ways in which you look especially to protect racial minorities when the political processes are not open to them, work against them. And if you look at the debate in the Michigan Proposal 2, the Affirmative Action Ballot Initiative, it was the most racially polarized election in 50 years in Michigan. There was a 51% split between the way white voters felt and the way black voters felt, bigger than the split between white and black voters in 1956 about Brown, bigger than the split between white and black voters in 1964 about the 1964 Civil Rights Act and public accommodations, bigger than the split between white and black voters in 1968 after the riots in Los Angeles and Detroit. So this was a racially charged election in which you have a minority of blacks who are always going to be submerged within a white majority. And so simply saying any issue involving race, we throw it to a ballot-wide initiative, you're essentially saying that minority groups can never win because they're always going to be submerged within this larger electorate.
Neal, you clerked for Justice Breyer. I want you to give us a sense of his opinion in the Schuette case. Do you think he was right?
I do think he was right, and indeed the bigger point is I think that this is Justice Breyer's best term in 20 years on the court. We can talk about recess appointments and Ted's point in a minute, but on Schuette, I think what Justice Breyer said is this, and I wholeheartedly agree with it. I believe in affirmative action in the university context, as does he, and what he's saying is, look, persuade people that this is the right thing to do at the ballot box. We can have a debate about whether it's constitutional or not. The conservatives on the court want to take it off the table, and even if legislatures, university administrators want to have affirmative action, the conservatives want to say, no, we want to use the power of judicial review to take that decision away from the people. And Breyer's jurisprudence for the last 2 decades, I think, culminates in this opinion in this case. He's saying, look, that's a question for voters to decide. If they want to, after we decide the University of Michigan affirmative action case in 2003, if they want to prohibit affirmative action, that's their choice. And yes, it's going to burden minorities in many ways. Of course, I think one theory of affirmative action, and the dominant theory at the court, is affirmative action isn't just for minorities, it's for everyone. And if we say that it's constitutionally compelled, and I think this is Breyer's point, if we force them to have affirmative action, how are we ever going to really persuade people that it's the right thing to do? Rather, we should do that organically. We should sell it at the ballot box and persuade people this is the right way for our universities to operate.
But the problem is that was exactly the same argument that was made in earlier cases that developed this political restructuring doctrine about busing, right? About housing desegregation. And what the Supreme Court said in those cases is that you can't just throw it to the voters, and that it's not simply by referendum, and that when you do, you're essentially consigning minority groups to never being able to exercise rights that are held under the Constitution, as in the Grutter and Gratz case, and you're essentially creating a higher bar for them that every other special interest group can simply make their appeals through the process of negotiation, and this one particular group, which is a minority, is always going to have to appeal to the entire electorate in order to win.
I think these restructuring cases are on tenuous ground, but I think that they at least can be justified on the idea that busing or something like that is to prevent a constitutional violation. I think affirmative action is in a different category. I don't think that people have a constitutional right to affirmative action. Rather, I think that's something that people have to decide and voters have to decide for themselves.
I'll add one more thing. We could discuss this for a long time, obviously, but the whole issue of referenda and initiatives came up in the sexual orientation context in Romer versus Colorado a few years ago, where it was Amendment 2 or something like that, that took away rights of gays and lesbians from protection by statutes and municipal codes that provided them for protection against discrimination. And in a sense, that Supreme Court decision written by Justice Kennedy was a restructuring case. Way back in California Proposition 14, remember that? In 1960s, California, that was another one that was a referendum. In the gay marriage case that I was involved in California, we had political scientists talk about what happens to minorities in the statewide. The referendum process was developed initially to provide a check on corrupt legislatures and throw the power back to the people. But we had testimony in the case in California involving sexual orientation, marriage equality, that gays and lesbians had lost something like 30 straight elections like that because people would put it on the ballots, and minorities lose when you put things on the ballot like that, as opposed to what's happened in the give and take in legislature. I'm not necessarily on one side or the other about that, but there's strong empirical evidence that minorities do suffer in those kind of statewide elections, even though the power is being given to the people where we all think that it's supposed to reside.
Let me just say one thing, because I think people do get confused. So the Grutter case still survives. Affirmative action is still constitutional. What was decided in that case is that a state can have a referendum that decides not to use it in their particular state. And so the question now is, how many other states will follow Michigan? There are a few others who have already done so. Obviously, California led with this. And that's the question on the table. Are there going to be now copycat states that are going to pass these referenda as Michigan did?
So we've seen two big areas, at least, in this fascinating discussion, where the court could have taken a broad position, saying affirmative action is completely banned, or in Ted's case last year, marriage equality is absolutely compelled by the Constitution. And it rejected both of those positions. It took a narrower, more legalistic position, as Chief Justice Roberts pledged to do when he said that these more narrow legalistic positions could get people of both sides to converge. I want to ask about one unanimous decision that I'm sure will interest our audience, and we all want to know what to think of it, and that's the abortion clinic protest case. Why was it, Neal, that the four liberal justices joined the 5 conservatives in striking down Massachusetts' bubble law, and does that call into question the other state laws which say that you can't come within a certain distance of an abortion?
I'm going to refer to my co-counsel on that question, because I'm not following that case quite as closely as maybe some others.
Well, the interesting thing is, was it 35 feet, the buffer zone? Abortion protesters outside of an abortion clinic could not come within 35 feet. So you have the issue of people seeking to exercise their constitutional right under the Supreme Court's decision to have an abortion, and people exercising their constitutional right under the First Amendment to tell people and harangue people, harass people, or to provide information, whatever it might be, the abortion protesters. It's interesting because the buffer zone around the Supreme Court itself is larger than 35 feet. If you've ever tried to protest, those of you in this Aspen group, I know they're there often.
Yes.
But what the court was struggling with, and why the liberal justices went along with the majority there in that case, is that it was a relatively fact-specific decision. The court was deciding that 35 feet is too far, that people can, and they had decided just a year or two ago, the protesters, this Baptist church in the Midwest someplace, that wanted to protest at military funerals and holler out nasty, nasty things to the poor bereaved family who's trying to put a soldier to rest. And the Supreme Court upheld the right of the protesters to make noise and to protest on a fact-specific decision given based upon how far away they were, how much noise they were, could they be heard, and that sort of thing. So the liberals justices went along, I think, with this decision, saying that the Massachusetts limitation was too broad, that people were entitled to be closer to that. It's going to throw it back to the legislature. It angered the 4 conservative members of the court who very strong, I think it was 4, the conservative members of the court saying, you're putting speech in different categories. Justice Scalia, I said before, he write in his concurring opinions, this is one where it's a very strong, he said, we're writing in the majority here an abridged edition of the First Amendment applicable to speech against abortion. And then he calls it on a subsequent page, abortion speech only jurisprudence. The point that they were making is that you're making content decisions with respect to the nature of speech. If it was speech about some other subject, you wouldn't have the idea of these buffer zones at all. But because speech, abortion is perceived in a certain way. Protesting abortion is going to be perceived more harshly, and limits are going to be, even limits such as the one they were talking about here, it's going to be more severe restrictions permitted by people, in the abortion context than in other contexts. And so there was a content restriction, and the dissent, or the concurrence, was very strongly on that basis. Do
you want to weigh in with the
Yeah,
judges?
I do. So this was a case where you had to really carefully parse and what the court purported to be looking at and the record. And since I'm a believer in the record, you have to accept the record that you get. And in fact, this case wasn't about abortion protesters, right? So what the individuals said, or what the group said in this particular case, was that they weren't abortion protesters, that in fact they were counselors, right? That what they wanted to do within this 35-foot zone was quite different than holding up placards and signs. That essentially what they would say was, can I walk with you? Do you want me to counsel you? And some people would have the rosary or whatever they claimed. And this was apparently unrefuted, that this is what this particular group was engaged in. And I think the 4 justices were very much aware that many other states, New York and others, have pretty powerful laws about buffer zones for protesters, and have actually criminal penalties that attach to harassing, following, intimidating, obstructing anyone from entering an abortion clinic. And I think what the court thought was that those kinds of means are sufficient to hold back the people who would be the kinds of more aggressive protesters. And so they were willing to go along with this 35-foot, may I walk with you. Now, I think many of us are not satisfied with that because, frankly, this is a very personal decision. It's personal space, it's personal time, and frankly, 35 feet. Electioneering, you go to the polls, it's 100 feet. You can't hand out leaflets before you go into a polling place. I don't think anybody thinks that 35 feet is an incredible amount of space. So it's a bit of a strange decision, but I read it very carefully, and I think that the 4 more, I wouldn't call them liberal, but more centrist justices thought that they were engaged, as Ted said, in a very specific fact situation.
But some of the speech, and there was a record, was broader than what the court was actually dealing with. Some of it wasn't, may I walk with you? Some of it was, this is, you're killing a life. And the slippery slope there is, if you start making decisions based upon this is counseling as opposed to protesting. Is it nice speech? Is it benign speech? Is it polite speech? Is it robust speech? That is really tricky.
No question. And you'll remember that Justice Scalia's concurrence, what he was so angry about, was that he believes that any buffer is attacking a speech based on its content, that he believes that this is about people, as you say, who are opposed to abortion. And the court refused to accept the idea that this was some kind of attack on the content of the speech. And that's what he was mostly angry about. He wanted the buffer zones branded as being efforts to get at those who are against abortion. And so I think the decision is deeply, deeply troubling in many ways. I'm not exactly sure what the 4 justices were up to, but I think they are hoping, and frankly, one of the reasons I worry is because I've seen these justices do that in other cases where they hope, as in the Northwest Austin case before the Shelby case and so forth, that if they walk this narrow path, they may be able to circumvent greater damage, and I'm not sure it's true.
So what Sherrilyn is saying here is a real concern that she has. The Northwest Austin case was one that Neal argued so ably, and that was the first big voting rights case, and lots of people expected the Supreme Court to strike down the Voting Rights Act by a vote of 5-4, which they ended up doing last year. But in that case, Chief Justice Roberts came up with a position that hadn't, I think, occurred even to Neal, arguing for the government, a very legalistic exception for this particular fact pattern. The liberal justices went along.
Neal was silently advocating the position that ultimately won.
They were channeling him for sort of brain scans or something like that.
You
would have thought of it.
I would just say the Legal Defense Fund also argued that case, the Northwest Austin case.
Please,
as well.
oh my goodness, had you thought of the position that the Chief Justice Roberts came up with?
Internally, yes.
Internally, yes. No, it was, he sort of pulled it out of a hat, and the liberal justices went along, and later they suggested that they'd been duped because the court actually pulled the trigger and took the broad position that it resisted doing before. We've been talking about the First Amendment. There are 2 other really big First Amendment cases that we need to talk about, at least before starting a conversation with our friends in the audience. The first and most closely watched was the Hobby Lobby case, which came down on Monday. Neal, tell us what Justice Alito held and tell us whether you agree with him or with Justice Ginsburg, who found the decision startling in its breadth when it held that religiously motivated for-profit corporations are entitled to an exemption from the Affordable Care Act's contraception mandate.
Great. And so the big point about this is not about Hobby Lobby, it's about Justice Alito. I mean, and Ted, you may agree with this, but as I go up and argue at the court, I've been struck each year by how good Alito's questions are each time. I mean, they are so analytic, so powerful. And this term, I think we saw him emerge as a leader, not in the oral arguments, but actually in the written opinions. And so the last day of the term, usually those opinions are written by the Chief Justice or the second most senior justice. Justice Alito hands down both opinions, both in Hobby Lobby, which I'll talk about in a moment, as also Harris versus Quinn, the big public union case as well. So Alito has really, I think, emerged as a leader in this term. It's a really interesting thing to see. The question in the Hobby Lobby case is whether a closely held corporation that objects to the part of Obamacare that requires them to pay for contraceptive, the so-called contraception mandate, whether or not that violates religious freedom principles that Congress has laid down in a statute called RFRA, the Religious Freedom Restoration Act. And what Justice Alito said is, this is a corporation, it's a closely held corporation, they have rights too. Just like ordinary people, and they can, and this should not be surprising. As I said, elections have consequences. This is, I think, a position that that this lineup on the court has held for a while. Ted, I think, was one of the leaders in pushing it in the Citizens United case. Corporations have first
You mentioned Bush versus Gore and Citizens United. I'm going to be run out of town on a rail.
I told you. I think you've got some insulation.
Stuff.
We'll talk about your future in a moment, and I think they'll be perfectly happy with your advocacy. But at the end of the day, Justice Alito says 5-4 that corporations have these rights and that Hobby Lobby shouldn't be forced to pay for this contraception. And what they say is, look, the government has a less restrictive means available to it. The government can just pay for it. There's no reason to have the government forcing these religious corporations to have to pay for it. Justice Ginsburg, in her dissent, says this is a sweeping decision, that this is going to change the landscape of law, that employers are going to object to vaccinations and the like. She says it's not limited to just closely held corporations. It might apply to public corporations. There's no logical stopping point. So this debate is going to continue for a long time. It's a full employment act for lawyers, to be sure. But this is one in which the court was closely divided, and Alito really leads the court in a certain direction.
Ted, Neal referenced the Citizens United case where you successfully argued.
So you're going to rub it in.
No. Well, I promised a nonpartisan debate here in Aspen, Colorado. Citizens United Justice Kennedy held that corporations have the same First Amendment rights as natural persons when it comes to campaign finance spending. Hobby Lobby was not decided on constitutional grounds. It was the Religious Freedom Restoration Act. Do you feel, however, that a majority of the Supreme Court is sympathetic to the idea that corporations have First Amendment free speech and religious liberty rights?
Well, first of all, the question is, do corporations have constitutional rights under the Bill of Rights? And that sort of became an issue after Citizens United because people were very unhappy with Citizens United because some of the people said, well, corporations aren't entitled to constitutional rights under the Bill of Rights. But the Supreme Court had held scores of times, and there's footnotes elaborating all these decisions that corporations do have constitutional rights. One of the leading cases, notwithstanding the New York Times' editorials against Citizens United, was a case called New York Times versus Sullivan. And another one was the United States versus New York Times, which was the Pentagon Papers case, in which the New York Times really did think that they had constitutional rights, and they won. And corporations have rights against searches. They have rights when the government wants to take property of corporations. So that was one issue. The other issue in the Citizens United case, and there's many, what another issue was, that was a nonprofit ideological corporation. It wasn't a big public shareholder. Speaking of closely held corporations, that was pretty much, that was a very, very tiny little corporation that wanted to make a movie about whether or not a particular person should be qualified to run for president. Now, this case is rather interesting because it extends, or it talks about the rights of, it was a statutory case, not a constitutional case, but it talked about whether or not corporations can have religious views. I'm sort of sympathetic to the dissent in this case, and I was thinking as we were talking about it just this week before the decision that, and they talk about the corporation might be against vaccinations. What about the Christian Scientists? Against doctors, and I'm maybe not stating their doctrine correctly, but you can see people in having those kind of views saying, I don't want to pay for insurance for my health insurance for my employees at all. I don't know where the line can be drawn, and we're the pivotal point here. This is really a 4-1-4 decision. Justice Kennedy writes a relatively short concurring opinion, putting oil on troubled water, saying it's not going very far, it's not going to happen with public corporations, it's just closely held corporations, it's just this one particular piece of insurance, it's not all kinds of insurance, and all of those things. But I agree with Neal, this is just a minefield for lawyers. What in the world is a closely held corporation? I mean, how many shareholders, or how many small a number is it? And when you get, does the corporation have religious convictions? Certainly its owners do, but they have decided to engage in commerce. So it's got a lot of issues that people are going to be litigating for years.
Closely held corporation can be 5 family members. The Walmart Corporation could qualify as closely held under that
You want to
definition.
talk about the devil? Talk about David and Charles Koch.
No constitutional debate on a non-partisan basis. None of that, ladies and gentlemen. Sherrilyn, what about Hobby Lobby?
Lobby has 16,000 employees. A for-profit corporation exists first and foremost to make money, to make profits. And it's true that its owners may have a whole range of beliefs, but I think notwithstanding that corporations have some constitutional rights of the kind involving search and seizure and so forth that Ted described, I think many of us are astonished to learn that corporations have feelings, for-profit corporations, that they have feelings and sincere beliefs. So we're defining what is a closely held corporation. We're also defining how can we tell that your beliefs are sincerely held. I mean, I think for an individual, a person, I can imagine how, as a lawyer, I would go about probing whether a belief they purport to hold is a sincerely held belief. I'm not sure how I do that with a corporation. Does it matter that Hobby Lobby's employee retirement plan is invested in the very pharmaceutical companies that make the morning after pill, for example? Does that hold up with the idea that they have this sincere belief about the morning after pill and abortion? So how do we cabin this? I, like Ted, beyond being concerned about this particular case in which a woman's access to the full range of contraception can be inhibited by the beliefs, even if those beliefs are irrational, the belief that an IUD is an abortifacient, even if the belief is irrational, that belief can prevent a company from having to extend their health benefits. I really actually am interested in Ted's view about how this affects the issue of same-sex partnerships. In other words, if the owners of the corporation, if the corporation sincerely believes that gay marriage is wrong and is against their religion, can they refuse to extend family benefits to a partner or to a child who has come out? If this is a religion that doesn't believe in interracial marriages, can they refuse to extend family benefits to someone of another race? If this is a corporation that doesn't believe in blood transfusions, if this is a corporation that doesn't believe in vaccines, I think, it's for Justice Kennedy to try to put oil, to smooth the waters and say, this is not a slippery slope. That's the first sign it's a slippery slope. This decision is absolutely astounding to me. Absolutely astounding. I don't cheer on Justice Alito on this. I think this is a powerfully disturbing decision that we should all be very concerned about.
All of those we can take constitutional votes at the end as well. But Justice Alito did dismiss Justice Ginsburg's concern that a wedding photographer who objected to gay weddings should not have to photograph them, a case the court refused to hear recently. And more broadly, Sherrilyn, you've raised the question, should we take the court seriously when it says this opinion is a ticket for one train only? Justice Kennedy said that in Bush v. Gore as well. He said, don't worry, there won't be any other litigation. And in fact, every election since then has invoked that case. I think I want to very quickly ask your opinion about the McCutcheon campaign finance case, and then we're going to open up for questions, and I'm going to ask Neal, because Ted, has an iron in the fire with Citizens United. Does McCutcheon signal a further erosion of the idea that you can regulate contributions but not expenditures, because it defined campaign corruption so narrowly, basically requiring quid pro quo corruption, that evidence that the donors were dependent on the funders will no longer be cognizable?
Right, so the question in the case is the aggregate contribution limits and whether or not they're constitutional or not, and the Supreme Court 5-4 strikes them down. I didn't find McCutcheon itself to be all that surprising. I think, again, it's the same predictable lineup that we've seen for a while in the free speech campaign finance cases led by Citizens United. That's really, to me, where the real groundwork was, which was dismissing the corruption charges there. And McCutcheon, I think, maybe pushed it a little bit, but the court in McCutcheon, just as in many cases this term, didn't go as far as the folks who were arguing it advocated. So in this case, they said you should overrule Buckley versus Vallejo, the 1976 case, which established the constitutionality of campaign finance regulation. The court didn't go so far as to do that. They've cut it back. We've seen that time and again in so many different cases, the shitty affirmative action case, lots of other cases this term, business cases, Halliburton and the like, in which the court didn't go so far as to overrule precedent. This is a term that is characterized, I think, broadly by trying to respect the prior precedents that the court has laid down before, but cutting and chipping away at them and signaling to the future. Who knows? It might be up for grabs. We might be in a slippery slope situation. But this term, they I think, ruled more narrowly.
Wonderful. Well, that was a superb and fast-paced review of the best arguments on both sides of these incredible Supreme Court cases. We have 10 minutes for questions. Yes, ma'am. There should be a mic roving around, although it may be very hard to reach you because there's not much space between the seats. Here it comes.
Thank you very much. I'd like to ask a question about the last 8 years of the Roberts Court. And let me say, Sherrilyn's right, that in terms of the controversial, it has been 5-4. But I go back to his confirmation hearing, where he was brilliant, and he claimed that he would be an umpire calling balls and strikes and would not overturn law. He had some very interesting things to actually say about the Voting Rights Act. Do you all think, Neal, Cheryl, and Ted, that he has followed what he said in his confirmation hearings?
So that we can get a lot of questions in the short time, I'm going to just direct it to individuals. And Neal, you talked about Roberts in your op-ed. What do you think about that?
So, I mean, I hold the chief's chair at my law firm, so I might be a little biased on this. But I do think that that the chief has done a good job. And the best example of this is the Affordable Care Act. Who would have thought, watching those confirmation hearings, that John Roberts would cast the deciding vote to save President Obama's health care plan and indeed perhaps his presidency? I do think that took remarkable courage and was a vindication of the promise. Now, obviously, in those hearings, he said a lot of other stuff, and he's been true to it on things like affirmative action and race neutrality, on campaign finance and the First Amendment. So we're going to see a divided court for years to come, but there have been some, I think, unexpected developments along those lines.
You know, just in the interest of debate, I think I should ask Sherrilyn whether you agree.
How do you know I don't agree with you?
I don't know. I'm just asking the question.
I would say the following, that, well, first of all, the statement itself, you know, is subject to a lot of criticism that we don't really have time for. I would say that where I find most of the distress about Justice Roberts and what he's done is, you know, I think we very often don't look to the breadth of power that the justices have, and it's not just about deciding the cases, it's about deciding which cases to take. It's about deciding whether or not you're going to change the question presented in a case to turn the case into one that you want to decide rather than one that was really in contention between the parties. It's whether you're going to invite parties to tee up an issue that you care about hearing. It's whether you're going to decide to ignore the record. You know, let me just say something for, you know, Supreme Court litigation is a wonderful thing and it adds great luster to all of our careers. but speaking as someone who also cares about being a trial lawyer, what trial lawyers do is they create a record. They educate the court about the things that the court doesn't know. And where I think I fault Justice Roberts the most is in lacking the humility to recognize what he doesn't know. I don't think Justice Roberts knows that much about race. I would like, in the course of litigation, not through a speech, but through the presentation of evidence, to be able to present him with what he doesn't know and to have him accept that he doesn't know and to have him weigh that evidence. I don't think he did that in the Shelby County case. I don't think he was willing to accept the evidence that was in the record. He had his own view about race and voting rights. So I don't think that's being an umpire calling balls and strikes, nor do I think that is really the best way that a judge can use their power. Because at the end of the day, you're the 800-pound gorilla, you're the judge, you get to decide. But you know, we lawyers, we're not potted plants. We're there for a reason. We're there to present evidence and to educate the court. And what I would like to see more from the Roberts Court, particularly from the conservative justices, and that includes Roberts and Scalia, Alito, and so forth, and particularly as it relates to issues of race, because I'm being honest with you, I don't know where their expertise on race comes from, but they seem to think they have it. And I think it would be really useful for them as judges to listen.
We have time for just one or two more questions. And yes, sir, in the back.
Thank you. I wanted to ask about a case that I thought was extremely important. It hasn't come to the Supreme Court yet. It was a California case called Vergara versus California. And basically, the tenure and seniority laws of teachers were struck down because the court found that those laws disproportionately affected poor and minority students and saddled them with incompetent teachers. Now there are other cases in other states that are going to come on the same line of legal argument. I wanted to know your reaction to that case, whether you think there are going to be continued wins, and also how the Supreme Court, might look at one of those cases when it gets there. Thank you.
It is an absolutely fascinating case and a great note on which to end. Ted, I know your firm argued the case. Ted Boutros won the case. And what's so interesting about this case, ladies and gentlemen, is there's a logjam between the teachers' unions and some of their challengers. And here this judge said that these teacher tenure laws are actually resulting in such bad teaching that they're disadvantaging African American and minority students and therefore violating their equal protection rights to a fair education under the California Constitution. Ted, just very briefly, the gentleman asked, how significant is this? Will it have legs? And what I want to ask you is, this was under the California state constitution. Could you imagine the Supreme Court and the conservative justices of the Roberts Court buying this rather expansive idea of educational equality that they've rejected in other contexts?
All right, I'll try to be very brief because I know the time is limited. We did handle that case. I spent some time in the trial court during that case, and we have developed it. It is under the California Constitution, which has very strong provisions about the rights for quality education, equality education and quality education. That's in the California Constitution. There are several California Supreme Court decisions that flesh out that right. So this case was entirely litigated under the California Constitution. It will have legs. It has to do with the fact that teachers were getting tenure after 18 months, no matter what level of maybe their first grade teachers getting tenure after 18 months before even the review process was completed, and then there was provisions that made it provisions in the statute that called it permanent employment. So you could not, if there were some teachers that were manifestly incompetent, maybe they had drug addiction, maybe they had mental problems, and maybe they had this, that, or the other problems, these teachers could not be removed except for Herculean expensive efforts. So school boards were giving up. They were just cycling, they called it the parade of the dance of the lemons, because they were moving these incompetent teachers into the inner cities where the children that needed the education opportunities the most were getting the worst education. So, I mean, that's a very quick and unfair summary of the thing. There are other cases coming. There's one already filed in New York. There's different state constitutions and different state laws. And I was talking about whether or not something can be done. There have been cases in the United States, Plyler versus Doe, involving educational rights and equal protection under the United States Constitution. You can, it seems to me, construct a solid legal argument about that. It'll be very difficult because judges, and one of the things we thought about in this case, judges are not going to run schools. They're not equipped to run schools. They shouldn't be running schools. And so they're not, you have to look at the decree. The decree in this case just struck down, and it's just a trial court thing. It's going to have to go up in the appellate process in California. They struck down the statutes that locked in these incompetent teachers, and then the legislature is going to have to do something to fix it. But I do predict that there will be cases in other states, and someone's going to file a federal constitutional challenge where the state law is not conducive.
Neal asked for the last word for 15 seconds, so to maintain peace at the Thanksgiving table, I'm going to give it to him. 15 seconds.
So Ted's Vergara case is not going to go to the Supreme Court this year, but Ted's other case on gay marriage, I think, likely will. And Ted has done a remarkable service to the country in bringing these cases along with lots of other lawyers. I predict Ted's going to argue this case and win it, and it will not be 5-4.
Ladies and
Thank you.
Ladies and gentlemen, there was a chuckle when I began this discussion by saying that the National Constitution Center, like the Aspen Institute, is committed to the idea of nonpartisan debate. But this brilliant panel, these are the three best Supreme Court advocates in the country, has proved that that there are good arguments on both sides of all constitutional issues, and when presented with them in a sophisticated, fair, and energetic manner, you, the people, can be educated and can make up your own minds. Please join me in thanking Neal, Sherrilyn, and Ted.